I beg leave to ask this question standing in my name on the order paper.
I call the Minister. Lord Wilson of Tredegar.
My Lords, where there is evidence of an intention to kill or cause serious injury, then offences committed by motorists will be prosecuted in the same way as other homicides or assaults. But in the context of driving, it's often difficult to ascertain the driver's state of mind or intentions. And that's why the law contains additional road traffic offences that consider an objective test of the standard of driving rather than the driver's subjective intent.
In 2014, a man travelling at 88 miles an hour in his car drove straight at the traffic officer who tried to flag him down to stop him. The killer made no attempt to swerve or to slow, and he threw PC Duncan into the air like a rag doll. He left him with fatal injuries. And the starting point for murdering a police officer with a knife or an iron bar is 30 years. This driver got an 8.5-year sentence. Now, is that justice?
My Lords, first of all, I should acknowledge the gravity of that incident, and we should pay our respects to the police officer's family. Remember the work police officers do day in and day out. But one has to distinguish the road traffic offence from the consequences. In that case, if there was sufficient evidence to prosecute for murder or manslaughter, that prosecution should have been brought. And I know the CPS do bring those charges when there is evidence to support them and when there is a sufficient likelihood of a guilty